Good afternoon. My name is Whitney Barth, and I'm the Executive Director of the Center for the Study of Law and Religion here at Emory. I'm delighted to be here with you today, and so we can host this wonderful scholar, Nadav Berman, from the University of Haifa. I'll do formal introductions in a moment, and I'm pleased that our colleagues from Emory Law, Professor Hallie, Ludsin, and Professor Michael Broyde are the respondents. We're also very much looking forward to hearing from you as well as we get started in the conversation. If you haven't already gotten lunch and you're in person, please make your way to the back table and make sure you get something to eat. Just want to say a warm welcome to all the students from the Emory College who are here. Thank you for crossing the campus to be with us today. And thanks to everybody who's joining us by Zoom. We're delighted to have you with us for this conversation. And thanks to all of our Emory Law colleagues as well for joining us. As many of you may know, the Center for the Study of Law and Religion at Emory promotes and produces innovative research and scholarship, exemplary teaching and training, and robust public engagement at the intersections of law and religion. This is just one example of the kind of public programs that we host here at the center. We also have a number of publications, including the Journal of Law and Religion, which our speaker, Dr. Berman, has contributed to in the past, as well as Canopy Forum, our online digital publication of shorter essays on the intersection of law and religion. We also work with Emory Law on the law and religion concentration in the JD program. So if any of the law students here want to talk to me about that, I'm here. I'm the concentration advisor. I'd be happy to talk with you. And we do a number of different things, like I said, at this intersection of law and religion. So we're delighted that you're here to be with us for this particular conversation. And I'd like to take a moment to thank some of my Emory Center colleagues, in particular, Dr. John Bernal, our Director of Digital Scholarship, Ms. Catherine Loftus, our Administrative Assistant, and Ms. Amy Wheeler, our Chief of Staff. So thank you all for everything that made this event possible. And thank you to our wonderful SJD candidate, Alexa Windsor, who's allowing me to use her computer today when I had some technical difficulties with my own Zoom. So thank you for that. And speaking of technical difficulties, I've been told there may be some challenges with the sound on Zoom. So if you're a Zoom participant and you're having an issue with your sound, it may cut in and out. We're aware of it, but we will also be posting this on our website. If you miss any portion of it, please check it out there, but we hope you'll stick with us. So don't go anywhere. It's sure to be a lively conversation. So without further ado, I'll go ahead with our brief introductions. There's so much more I could say about each one of these individuals, illustrious in their own right, but I will keep it brief for the sake of time so we can go ahead and get started in our conversation. Our guest, Dr. Nadav Berman, recently completed a Kreitman postdoctoral fellowship at the Goldstein-Gorin Department of Jewish Thought, Ben-Gurion University of the Negev, where he examined Jewish thought vis-a-vis the Christian agape. Prior to that, Nadav was a postdoctoral associate at Yale University's Jewish Studies program. His doctoral work invested philosophical links between pragmatism and Jewish thought. Nadav is currently a research fellow at the Faculty of Law, University of Haifa, where he co-leads with Professor Tal Zarsky an ISF-funded interdisciplinary research on intersections between Jewish thought, law, and technology. Their collaborative article, What is the Juxtaposition Between Silicon Valley and Mount Sinai? Covenantal Principles and the Conceptualization of Platform User Relations, was published in our very own Journal of Law and Religion in 2022. So Dr. Berman, thank you so much for being with us. We're delighted to have you here. Professor Michael J. Broyde is a professor of law at Emory University School of Law and the director of the SJD program here. He's also Berman Projects Director within our center. He is a core faculty member of the TAM Institute of Jewish Studies at Emory, and his primary areas of interest are law and religion, Jewish law and ethics, family law, and comparative religious law. He has been a senior Fulbright scholar at Hebrew University and a visiting professor of law at Stanford, University of Warsaw, and the Interdisciplinary College of Law at Herzliya, Israel. He is the author of numerous books and more than 250 articles and book chapters on various aspects of law and religion, Jewish law, and religious ethics, as well as an often cited article on impeachment in the Harvard Journal of Law and Public Policy. So thank you, Professor Broyde, for being with us. Professor Hallie Ludsin is a human rights lawyer and a senior fellow at our center, and she's also affiliated faculty with the Center for International and Comparative Law here at Emory Law. Prior to Professor Ludsin's arrival in Atlanta, she spent 13 years working in conflict and post-conflict societies, and she served as a research director at the South Asian Human Rights Documentation Center in India and as a legal consultant to the Women's Center for Legal Aid and Counseling in the West Bank, the Center for Policy Alternatives in Sri Lanka, and the Center for Applied Legal Studies in South Africa. She returned to the United States as a democracy research fellow at Harvard's Ash Center for Democratic Governance and Innovation. And her book, Preventative Detention in the Democratic State, was published by Cambridge University Press in 2016. And she has had a number of articles in law reviews as well. So thank you, Professor Ludsin, for being with us. So why don't you join me and give me a round of applause for our wonderful participants today. So thank you all for being here, and I will turn it over to Professor Berman.
Okay. So hi, everyone. Let me start with making sure I know how to make it function. So thank you, first of all, Whitney, for this warm introduction. And thank you, Professor Rabbi Michael J. Broyde, for the invitation to speak here at Emory Center for the study of law and religion. And thank you, Whitney Bart and Amy Wheeler, for your kind help in organizing really the event and making it possible. Thank you again, Professor Broyde, and to you, Professor Hallie Ludsin, for willing to respond to my paper. Thank you all for coming here today. I look forward to hear your comments. And let me just mention one thing, maybe as I'm an American citizen, but also an Israeli citizen, as an Israeli citizen, I wish to mention that 134 of my fellow Israelis are still hostages and captivated by Hamas for already 139 days. Like many others, I pray for their immediate return safely and for a peaceful resolution for the highly complicated Palestinian-Israeli conflict. And as we're here at Emory's Center for the Study of Law and Religion, it is worthy that we may harness religious traditions involved in this conflict, Jewish, Muslim, Christian, perhaps others, in order to promote such a peaceful resolution. And it remains a great local and global challenge. So, having said that, let us start. So I wish to make three arguments today. First, there is a basic philosophical and sociological distinction that matters legally between orthopraxy and orthodoxy. Insofar as a legal trajectory is orthopractic or pragmatist, in this regard, it focuses on morally good actions. On the other hand, the legal culture that centers primarily on intentions, subjective ponderings, or inner motivations, all very important in their own regard, is in this sense orthodox. Second assertion or argument, Jewish law, halakha, in Hebrew, and Jewish tradition more broadly lean toward orthopraxy. I will demonstrate this assertion within halakha, though briefly, and trace its theological roots in the Hebrew Bible, mainly in the Pentateuch or Torah. Third argument is that orthodoxy, which exists in Judaism and in other religions, is vital, or at least can be vital, for thinking about privacy protection in the digital AI age. So let us proceed with some definitions. My use here of the terms orthopraxy and orthodoxy does not pertain to a particular Jewish denomination known as orthodoxy, nor to the Christian Orthodox or Roman Catholic Orthodox Church. It is rather conceptual and used here only as an ideal type. Jewish orthodoxy, to its sociological sub-branches, for instance, may well be orthopractic, insofar it is pragmatic oriented. Many or even most Orthodox Jewish thinkers, rabbis, and so on, in fact, lean, I believe, toward pragmatic ways of thinking. Orthopraxy, for its part, does not have a concrete sociological identification. This word is not taken as orthodoxy is. This word, orthopraxy, in fact, appears only a few times in a Google search. What orthopraxy means here, again, as an ideal type, is an emphasis on deeds. Ortho in Greek means correct, or um, or true. But praxis means action or deed or deeds. Orthodoxy, on the other hand, is an emphasis on right faith or belief, namely on the proper doxastic content that a person may hold in his or her mind. Now, intentions obviously matter and matter dramatically. In Jewish law and in any legal system, there are intention-based distinctions between, for example, willful crime and between inadvertent or unintended harm. This is why human beings once invented contracts and why contract law remains vital. Mere intentions are not enough for containing normative commitments and for solving and resolving conflicts between different claims of different parties. Even words, when remain spoken and not written, documented, might not suffice. By parole, the party is not obliged, as the phrase says. Regardless of differences between American and continental attitudes to will theory, namely how much weight should be given or assigned to intentions and moral motivations of the contracting parties, the basic tenet of legal systems is orthopractic, or simply orthopraxy. In the area of tort law, which scrutinizes what amounts to a harm, it is a commonplace that one's thoughts do not constitute a harm to another person. Deeds are the ultimate hallmark of law, at least in democratic countries. I would say in passing that it might be interesting to ask on a different occasion how the orthodoxy scheme maps into the division between normative jurisprudence and analytic jurisprudence, but not today. So let me suggest that democracies tend to be orthopractic. What we know as democracy is, I think, interchangeable with orthopraxy. But in dictatorships, supposedly, we find an increased attention to and targeting of people's minds, as George Orwell well noticed in his 1949 novel, 1984. Such governments, equipped with immense modern technologies of surveillance, care much about what people think and feel and how to control and manipulate the mentality and opinions of the masses. This governmental trajectory, governing the mental realm, is ultimately what I denote here by orthodoxy. At the same time, it would be exaggerated to say that dictatorships are merely orthodox in this regard. They do care about the good, or at least non-rebellious civic behavior of the citizens, as it would matter to any non-dictatorial government. In the context of privacy protection, given the unprecedented surveillance and AI tools such as facial recognition and many others, there are many societal and legal concerns about the violation of people's right for an uninvaded inner space or mentality, namely for cognitive freedom. This concept is discussed inter alia by Nita Farhani in her 2012 article, Incriminating Thoughts, and by various others. So this concern applies to dictatorships, the concern about orthodoxy in this anti-democratic regard, but it applies also to democracies in the global world, in which the global world is dominated significantly by tech giants, as we all know, Alphabet, Meta, Apple, etc., which gather, archive, and deploy big data, including unprecedented amount of private informations on billions of people, including us, as you know. Despite democratic institutions, national and global, which address the threats and the harms to civic privacy, in particular the GDPR, the dictatorial potential or risk or slippery slope of technology remains, and I'm pointing out here an article by Yuval Noah Harari. This slippery slope of dictatorship is not confined then to capital D dictatorships. The obvious concern is a dictatorship forced top-down, but there is also a bottom-up concern which stems from the hyper-individualized societies, which arguably result in a quest for a strong leader, when nothing binds society together. Now, societies can be divided and atomized in endless ways, and orthodoxy in the sense of radical subjectivity may be the hallmark of a thriving society, but there is seemingly a tyrannical potential when people don't feel that they share much with significant others and with others in general, and most things divide them. And that each person lives in their own universe, or perhaps metaverse. An imaginary orthodoxy might yet be an orthodoxy in this regard. So my assumption is that cultures and societies may shift their focus to the subjective realm at the expense of a focus on normative behavior. Such nominalist or idealist shift took place in early modernity with the rationalist philosophy of René Descartes, the 17th century so-called founder of modern philosophy. Interestingly, according to the online Merriam-Webster dictionary, the first and known use of orthodoxy was in 1630. So I don't know what it means about Jewish orthodoxy, but it's a very interesting lexical point to consider. As we often think of orthodoxy as an ancient phenomenon, this etymological genealogy is striking. Despite the general scientific inclination in modernism toward empiricism and worldliness, the nominalistic urge remained forceful up to this day. In the 18th and 19th century, we can think of German idealism and romanticism as often shifting to otherworldly, reason or subjective human inwardness. Those are two of the seemingly opposed directions that coalesce. A society then does not need to be a dictatorship for there to exist an orthodoxy of some sort within it, or an orthodox potential. In the 20th and the 21st centuries, this subjective shift increasingly came to be associated with tech utopianism or tech admiration, often expressed by transhumanists, but not only, namely the belief that technological artifacts create a self-sufficient world, or perhaps metaverse, which according to its developers would become the main field of action for its practitioners. This universe is by no means a mere illusion. Within virtual, including VR spaces, it is indeed possible to perform acts by mere thinking, using electrodes and other computer-brain interfaces, mostly in medical context, but it is really up to humanity if it will become fashionable and just in general use. It was just published that Elon Musk announced that his Neuralink startup has for the first time implanted a chip in a human brain. It's not really the first time, but that's a milestone. Virtual interfaces can be operated today using finger touch body motion and so on, but the novel advancement is an unprecedented possibility for what we used to call telekinesis, influencing the world by a mere thought. This telekinesis is a moment, I suggest, when it becomes a significant and wide social phenomenon, will revolutionize our conventions and presumptions about the orthopraxy of our law and society, simply because what happens within the minds of individuals will have an enormous effects on the near and remote environment. To be sure, already today we can do things that would be considered unbelievable by an average 19th century person, and even by judges Samuel D. Warren and Louis Brandeis, authors of the foundational 1890 article on the right to privacy. Yet, clicking the computer mouse with our finger and making a robot pick an item on the other side of the globe are not the same as intending the click, thereby commanding the purchase. It's just not the same thing. Or think of a truck driver whose eye tracking sensors detect fatigue, perhaps way before he or she are aware of the fact of being tired. These examples demonstrate in which sense we are seemingly becoming an orthodox society, again in this applied and constructed sense. Think of the following more legal presumption. Self-defense is legitimate when a person threatens your life. Such threat is measured by his or her deeds, for example, approaching you with a knife. What happens when the risk may be dependent on the person's inner thoughts? These kind of questions concern the complicated bridge between technological orthopraxy and orthodoxy. In what follows, I wish to suggest that Jewish law and tradition may help in thinking about these novel questions by virtue of their practical thinking that I label here as orthopractic. As a caveat, I would stress that Judaism is not the sole resource or the only resource for such orthopraxis. In fact, I suggest elsewhere that Christian founders of classical American pragmatism, Peirce, James, Dewey, paved the philosophical way for thinking robustly about praxis-oriented normativity. They were Christians, not Jews. Maybe Hebraic in a broader sense, but yet Christians. However, Judaism still, I believe, has a unique contribution in this regard, early Jewish tradition in particular. Before we turn to Judaism, let me say a few words concerning the orthopraxy, orthodoxy scale or range in the context of Christianity and Islam. In Christianity, the creed versus deed scale has important reverberations. On the one camp, there are pragmatic theologians such as Thomas Aquinas who endorse worldliness and good deeds. Everything I say here is a generalization, open for your remarks in the Q&A. But it's really an introduction to things, so forgive me for any generalization I make. I made here a few of them. On the other side, Martin Luther, the great 16th century reformer, who is in many ways a founder of the modern world, besides Descartes, aforementioned, follows St. Paul in stating that the works of the heart are what matters, or the mind as we would call it today. In the orthodoxy scale, Luther's fideism, sola fide, by faith alone, clearly tends towards the orthodoxy pole. Luther's principle of sola gratia, redemption by God's grace alone, further weakens the purpose and forcefulness of human deeds, because it's not really up to us. However, on the other camp, that of orthopractic Christianity, in addition to Aquinas, we may recall William James and his meliorism, which is a sober or constrained optimism that underscores the role of human action in promoting redemption of human flourishing or failing to advance them. In the Muslim context, again, very broadly speaking, we may think of similar dialectics. On the one hand, Islam is very worldly and practical religion, and in this sense, orthopractic. A major example of that is the prohibition against alcohol. Right? You should keep your body on the ground. On the other hand, there arguably was a shift in early medieval Islam from orthopraxy to orthodoxy. As Shlomo C. Peel contends, we may think of religions as characterized by orthopraxy and orthodoxy, and as shifting between these poles. That's Peel in his 2014 article. Peel delineates such shift in medieval Islam, I quote, as law was applied to theology, theology was applied also to law, the focus of Islamic religiosity shifted from good deeds to correct beliefs. To be sure, and this is still by Peel, deeds and behaviors remained important in Islam. Sorry, that's me already, and not Peel, to be correct. To be sure, deeds and behaviors remained important in Islam, but creed-related issues prospered and became more central to Muslim self-definition, in particular vis-a-vis the external world. For example, converts and apostates. This Muslim Orthodox turn had allegedly influenced the turn to orthodoxy in medieval Jewish philosophy. So there was a trend in the Middle Ages in this regard. These non-exhaustive remarks, really broad and open to your critique about Christianity and Islam, are only to say that the orthodoxy scheme is applicative to Abrahamic religions and to world religions more broadly. In a comparative religions lens, we may say that even though there are important centers of mass in each world religion, Judaism and Islam, for example, being fairly orthopractic, perhaps, the tension between orthopraxy and orthodoxy ultimately exists within each and every religion. I'm not trying to simplify here a picture in which one religion has a monopoly over orthodoxy. Different constellations between orthodoxy and orthopraxy may exist in different eras and areas. Let us move to orthopraxy in Judaism. How much time do we have? Okay. So a good working definition of rabbinic orthodoxy and orthopraxy was provided by David Grossberg. By orthopraxy, he writes, I mean only that the Mishnah, early Talmudic texts of the days of the sages called Tanaim, intends, says Grossberg, to establish correct practice rather than correct beliefs. This is not necessarily to say that there are no foundational beliefs underlying Tanaitic Judaism, unquote. In fact, there are important principles of belief in Judaism, I concur, some of which even amount to dogma. Take, for example, the belief in God's oneness, namely monotheism, or God as a creator of the universe. This ideational or doxastic content is implemented in daily Jewish life and practice, in the prayer and tefillah. For example, in the recitation of Shema Yisrael, Hashem Eloheinu Hashem Echad, the Jewish Shahada, Hear, O Israel, our God is our Lord, our God is one, in Deuteronomy. That's a verse from Deuteronomy. But it would seem shallow or reductionist to say that there is that a mere recitation of the prayer, absent of any pious intention, is a genuine religious conduct. Or to say that Jewish beliefs are somehow wired in the believer's brain. So there's a tension here. Differently from such thin naturalistic conception of Jewish practice, orthopraxy does not mean metaphysics or spiritually free religious practice. It simply means that practice is indispensable to how to define religion. And practice, as we know from anthropology, is always thick and usually predicates on metaphysical assumptions. That's a very common notion by Clifford Geertz. The Talmudic picture changes in medieval Judaism, which centers more on deeds, on creed, dogmas, and so on. The most famous example is Moses Maimonides, Rambam, and his formulation of 13 principles of faith in his introduction to the commentary on Tractate Sanhedrin, Sanhedrin being the ancient Jewish high court. However, even Maimonides, who was establisher and popularizer of this dogmatic orthodoxy, was ultimately, I think, orthopractic due to his commitment as a rabbi and a scholar of Jewish law. And had Maimonides known the rise of orthodoxy in the modern period, he grew up before this, we call the Webster Dictionary. Maimonides might even agree with Menachem Kellner, who contends that, quote, to say that Judaism does not demand that we express beliefs about God and God's relationship to the world as a form of dogma is to say that all that Judaism demands of its adherents is a kind of mindless practice, unquote. So despite this Maimonidean orthodox trend, alleged trend, it is fair to say, I think, that medieval Judaism to its branches remained orthopractic, at least in a small case. I will now briefly describe orthodoxy in Jewish law, and then turn to the unique theology of the Hebrew Bible. An overarching question of this question, please bear in mind, is that of privacy protection and cognitive privacy in particular. We shall return to it in the concluding discussion. Orthopraxy has numerous appearances in halakha and Jewish law. For instance, there are in the Bible and post-biblical Jewish law many important distinctions between willful sin or crime, it's called mezid, and inadvertent or unintended harm, namely shogeg, as in the case of murder in Numbers 35. These distinctions were the ground for numerous Talmudic and later halachic discussions and deliberations in criminal cases, as well as in ritual cases called in Hebrew, this area is called Hisur ve'eter, ritual health, such as dietary laws, kashrut, and the unintentional eating of non-kosher food. Orthopraxy is expressed within or manifested within halakha in various contexts, and I will give but one example, which is a halachic rule that you see here, that unspoken matters of the heart are not considered legally. דברים שבלב אינם דברים. This maxim cited in the Babylonian Talmud, Tractate Kiddushin, 49b, from the name of the Amorah, the Talmudic sage Rava, clearly prioritizes deeds over vague intentions. The immediate context of this saying is acquisition law. If a person commits himself to sell a property and then change his or her mind, the condition that he might have in mind, but was not verbalized, uttered, and made explicit, does not bind the buyer legally. The duty to protect individual privacy is another instance of orthopraxy, which is very relevant to the broader topics that we are concerned with here. Tzinat haprat, or the intimate domain of the individual, is a basic good that the sages of halakha recognize and apply. For example, Rabbi Gershom, the light of the exile, Rabbi Gershom Meor HaGolah, of medieval Ashkenaz, prohibited the unauthorized opening of another person's letter. This prohibition is practical, physical. It is not about merely thinking of another person's letter or thoughts. The subject of privacy protection in Jewish law was researched extensively by Professor Nahum Rakover, professor scholars Mark Wachowski, Ken Bamberger, Ariel Evan Mays, and others. For our sake here, it is enough to say that this sensitivity of protecting the right of the individual to privacy existed in Jewish tradition way before the modern debates, and has its root in the concept of human dignity which in Judaism is called Tselem Elohim, Imago Dei, the createdness of all human beings in the image of God, based on the first chapters of the book of Genesis, right? It's just as you enter the Bible, it's hard to miss, even though some Jews allegedly missed this important principle. Let us turn now to examine the biblical or Hebraic orthopractic God, and we're approaching the end of my talk. So after reviewing some instances of orthopraxy in Jewish law, this section proposes that this orthopraxy is rooted in the theological and in some sense mythological picturing of the biblical God as non-omniscient. I do not mean that God's knowledge is ontologically or straightforwardly deficient. Rather, I mean that the fact that the Hebrew Bible, mainly in the 5 books of Moses, chooses to portray God this way is not incidental, but reveals something profound about the providential theology of the Hebrew Bible that may inform privacy protection discussions in the present. My main reference for deliberating the biblical phenomenon of divine testing, Nisayon, that's actually a Second Temple form of word, is a late Bible scholar, Jacob Licht, and his 1973 book, Testing in the Hebrew Scriptures and in Post-Biblical Judaism. As you can tell, it's not a great timing for any book in Jewish studies to be published, right? Yom Kippur War. So maybe perhaps for this reason, this themed book did not win the attention it merits. So I hope to do justice to this important scholarship. This work examines the biblical narratives of divine testing in cases where God tests humans and humans test God. I will briefly review Licht's main thesis without delving into the details of the biblical narratives that you surely know, such as the migration of Abraham, Sarah to Canaan, or the binding of Isaac. We may get to that in the Q&A. Licht states that the biblical testing implies that, quote, God does not know how the person will eventually act, unquote. You're all still sitting on your chair, so it doesn't surprise you much, but it runs contrary to a very prevalent notion of divine omniscience that, like the popular mind has in mind. To Licht's mind, this conception is unique to the Hebrew Bible and is distinct from other world literatures of the period, such as Greek tragedy, in which the hero is doomed to failure, which is known to the gods, and in fact destined by them. Licht further contends that, quote, so rooted in the Hebrew Bible is the feeling that a human being controls her actions, that will be gender inclusive. He wrote in the masculine, to do justice or evil, that scripture does not hesitate to assert that God thyself needs a testing in order to know what a human person will do, hence the empiricist God of the Hebrew Bible, unquote. So this biblical inclination implies that the Torah, its presumed divine author, is aware of the potential for treating the mental realm as a kind of activity, but yet refrain from policing it or policing it. This biblical orthopraxy is reflected in the narration of the Hebrew Bible. Okay. Sorry, here is a, yes, gradual revelation. So the focus on human behavior coalesces with the biblical depiction of God as empirical, non-omniscient viewer who asks the human creature, where are you? Or in the words of the Bible, word of the Bible, Ayeka, in Genesis 3:9. Thus granting him or her sphere of moral choice. But there's nothing trivial about this verse and about the idea it represents. So after saying a few things on the distinctions between orthodoxy and orthopraxy in the technological context, and saying some things about orthopraxy in Judaism, at least how I suggest to think about it, let me conclude with the following thoughts. So in the Hebrew Bible, there is an image of a non-omniscient God who chooses to respect human privacy and responsibility. This orthopractic worldview, I believe, was the basis for the Jewish or Hebraic covenantal notion of autonomy, which views the human creature as God's capable partner, rather than mere servant or subject. This intuition suggests, I think, robust moral lessons for democratic privacy protection in our so-called post-secular age. Against the Carl Schmittian assumption that human governance should strive really to achieve godlike omniscience and to know everything and to command everyone. The political theology of the Hebrew Bible, or minimally the Pentateuch, because the theological picture changes in later prophets, none of our business today, it suggests a radical and surprising lesson. Divine government can be understood as a benevolent respect for human privacy and freedom. This idea was developed robustly by the 16th century Lurianic Kabbalah, Jewish mysticism, and its concept of divine tzimtzum, contractions, or self-limitation by God, an idea which had important reverberations in Judaism, German idealism, and beyond. Is there a way, let me summarize, to mediate between the technological attempt to maximize human knowledge and data collection and between the legal attempt to protect human privacy as a primary human good? The orthopraxy scheme and the notion of Jewish orthopraxy as conceptualized here may offer a critical outlook on the present orthodox technological term and serve as a political theological road sign against the temptation of replacing our democratic orthopraxy with technological orthodoxy. So thank you for listening. I look forward to your comments.
Thank you, Dr. Berman. We'll now turn to Professor Hallie Ludsin for her response, and then we'll turn to Professor Michael Broyde for his response, and we'll give Dr. Berman a few minutes to respond to them, and then we'll open it up to questions for those of you who are here in person and on Zoom. So when we get to that time, if you're on Zoom, please just type your question into the box and we'll make sure to see it. Thanks. Professor Ludsin.
I can't see behind me. Am I on camera? Yes. Okay, excellent. All right. Thank you so much, Dr. Berman, for your wonderful talk. I really appreciated actually the opportunity to read this in advance and prepare some thoughts and comments. I am not a religious scholar. I am a human rights lawyer. I'm a human rights scholar. So my comments, my reflection is, in that lens, I'm staying in my lane. So I wanted to start off with, I understand why this is framed within the concept of privacy, but the practitioner in me sees some of your concern is about privacy, but that there are other rights that are, in some ways much more deeply involved than just privacy. So I kind of want to start there. Originally, I was going to ask you for, more examples of where you saw the violation of privacy, but you did give us some. So, when it comes to how do we gain person's private thoughts? So, the idea that we could maybe walk past technology and it can grab our thoughts from us, right? Maybe that's going to be possible in the future. The non-consensual taking of our private thoughts would certainly be a violation of a right to privacy. Again, I'm talking from an international human rights lens. It'd probably also be a violation of the right to security of the person, right? Because it's gaining your inner thoughts. If it comes to, where you have a chip in your brain and you've consented to, some information being used for specific purposes, but it's used for a different purpose. Again, we're within the realm of privacy, same idea with surveillance of our social media. But where the idea, and I think about orthopraxy and the idea or orthodoxy that, we're supposed to have the correct belief, the morally right beliefs, it's much more about, policing our thoughts. That brings me more into the realm of rights related to the right to freedom of thought, conscience, and it's actually religion under Article 8 of the International Covenant on Civil and Political Rights. As well as, potentially the right to freedom of opinion. And, so the act of trying to force somebody to believe something or to have those right thoughts, right intentions, or being prosecuted or punished for having the wrong thoughts, wrong intentions, for me feel less about privacy and, more about these other rights. So, I'd encourage to broaden past potentially just, right to privacy, because I think you have a really strong argument that, captures more than just the right to privacy. Let me just make sure I said everything I did want to say there. So there's 3 rights in international human rights law that I think follow your division or your understanding of orthopraxy and sort of support the fact that there might be, relationship between the Holocaust, orthopraxy and international human rights. And one of those, of course, is now going to be the right to freedom of thought, conscience, and religion. And I actually read out the text for y'all because I'm sure you want to hear it. Article 18.1 of the International Covenant on Civil and Political Rights reads, everyone shall have the right to freedom of thought, conscience, and religion. The right shall include the freedom to have or to adopt a religion or belief of his choice. This is subsection 1. And subsection 2, no one shall be subject to coercion, which would impair the freedom to have or to adopt a religion or belief of his choice. So it seems to forbid orthodoxy. Same thing with the right to freedom of opinion. So Article 9, again, of the International Covenant on Civil and Political Rights, everyone shall have the right to hold opinions without interference. So you can't coerce beliefs, you can't coerce thought, you can't coerce religion, can't coerce opinion or interfere with somebody's opinion. So that seemed like those would be additional rights that would kind of, relate to your orthopraxy split in the context of, this digital world we're in the midst of. Now, I want to separate out that while these rights, those right to thought, belief, opinion, religion, the actual beliefs themselves, that's an absolute right. You're not allowed to limit the prohibition effectively on coercion. Government under no circumstances has a justification to say you have to think differently. That changes when it comes to the context of how you act on it. And that was part of what, it seemed like you were targeting is what constitutes an act. But when it comes to international human rights law, governments are allowed to limit in the context of Article 18's right to thought, belief, and religion. You're allowed to limit the manifestation of that. And when it comes to Article 19's freedom of opinion, expression is usually the manifestation, the action. You are allowed to limit that, but even then in only narrow circumstances. So you can only limit those under international human rights law if for a legitimate purpose, and that legitimate purpose has to be either to protect public order, public health, public morals, or the rights of others. And public morals here have to be the entirety of the community and not a particular group, which again makes it very hard to kind of get orthodoxy in through that public morals clause. So I think both of those rights, sort of lend themselves to the argument that you're making in a sort of fuller picture from at least my international human rights standard. There's one more, which is the right to liberty. And you actually brought up an example of, potentials with right to liberty where you see orthopraxy, written into it. So here I'm talking about detention of people because they're considered dangerous. So not the prosecution, if somebody is convicted of a crime, I'm not talking there about preventive detention. You're allowed to be convicted of a crime and jailed. It's not necessarily, unless there's been a problem in the definition of the law or the due process, that's not going to be a problem. But here I'm talking about when you detain people simply because they have dangerous thoughts. Traditional, we have it in the United States, arguably we detain people who are considered dangerous on the basis of having been sexual offenders at certain jurisdictions like Minnesota. Certainly we know about Guantanamo detention. under the right to liberty in international human rights law, you're actually not allowed to detain people for dangerous thoughts. And the assumption, it is a rebuttable presumption, but the assumption under international human rights law, going to sort of your point about lift, is that we're capable of, choosing to do the right thing, even if we have those wrong thoughts. So, we have the will and ability to abide by what's right. So the exception, when are you allowed to detain people because they're dangerous? One of them is if you actually don't have the ability to act according to right and wrong. So mental health detention is usually justified on that basis, where you can be detained even if you haven't committed a crime. And when it comes to wartime detention or detention of enemy combatants, it's also an exception, because what is deemed to be right when you're an enemy soldier is going to be very different than that society that wants to detain you. So they're incapable of acting according to right. So I thought those would kind of help bolster some of, what you've been talking about in the examples that you've been giving us. And then I also really wanted to express my appreciation for your differentiating orthodoxy and orthopraxy, because believe it or not, I'm seeing this play out in that advocacy world. There's often now a purity test that happens in the advocacy world. So, I was kind of brought up more on the system. You're advocating for what you want to be the morally good deeds. Adopt a law, revoke a law, stop certain, actions that should be deemed criminal. And it didn't matter how you changed people's minds or gained the support you needed. You can meet people where they were at. You can meet them about the things that concern them and explain to them why those concerns either are actually a problem or why it actually might be beneficial according to their concerns. So very orthopractic in, the way we practice advocacy. And we're seeing more and more, and if you Google it, you too will see these purity tests. That's sort of the lay term for what, you've been talking about, that you actually have to advocate according to the right reasons. And there's a lot of almost infighting, I would say, within some organizations about, whether it's okay to seek the right action for different reasons or whether you have to be purist. So I actually have been thinking a lot about that because I'm teaching it in my human rights advocacy class, but hadn't put it in that framing. So I did want to thank you for that.
Did you want to pose your question?
Oh, yeah. So I did want to know sort of what you were seeing as the right to privacy. So again, international human rights law has a very different sort of conception, or at least I'm interpreting privacy differently than it seems many scholars and you are interpreting. So, when you're talking about privacy in the context of digital age, were you thinking of it as a combination of all of, both aspects of the privacy and the beliefs? Is it, so I was trying to dig, that was actually my biggest question for you, was really, what did you mean by a right to privacy?
We'll hold that, and then we'll hear from Professor Broyde, and then you can respond to.
Thank you very much for the presentation, and thank you very much for working. And I'm going to stand up because the microphone is right there. It's like a little bit easier.
You're off camera.
That's even better. Off camera is so much better. Off camera is so much better. I went to law school a long time ago with a professor, Harry Subin, who taught me criminal law. And he opened every criminal law class with two witty sayings. He used to stand up and say, kick people when they're down, because that's when they're least likely to kick you back. I'm not going to discuss that saying right now. But his second saying was, sincerity is the secret to success. And once you can fake that, you've got it made. And I want to focus on Professor Subin's second comment because it deeply resonates with this presentation. And I think it deeply resonates with Jewish law. Jewish law at its core recognizes that both orthodoxy and orthoprax is very important, mostly because determining why people do things is an extremely important way to measure how we should respond. Threats have to be real before we can respond to them violently. And determining whether a threat is real frequently is asking whether the person who muttered these words, "I'll kill you," it tends to carry through with the threat or not. And so too in many other areas of Jewish law. Jewish law imposes upon people a test not only of what they are doing, but what they are thinking. Of course, there's an obvious problem, which is we don't really know what people are thinking. And we can objectively evaluate frequently only what they are doing. And so the Jewish tradition, and I suspect like every other legal religious tradition, is caught between the two ideas of theoretical orthodoxy, but practical orthopraxis, because we have no way of evaluating what you're really thinking other than by evaluating what you're really doing, because we have no way of knowing what you're thinking. The expansion of telekinesis, as the term is used, or as Elon Musk's Neuralink puts forward, which is the diminution of this space between your thoughts and your actions. That's what we're really talking about. We're talking about the diminution of the space between your thoughts and your actions. On the whole, in the Jewish tradition, I think is positive. The gap between orthodoxy and orthopraxis, the idea that you should be evaluated by your thoughts and not your actions, but the reality, which is we can't evaluate your thoughts, so we have no choice but to look at your actions, is something that we view as the human condition. As Elon Musk and many others seem less bound by the human condition than I am, and are increasingly seeking to introduce technological change that accomplish what we previously thought were unaccomplishable. What we're confronting now is the bridge between our true thoughts and our true actions. No doubt, I think, the Jewish tradition looks at that as, on the whole, a positive activity, because we would like to live in a world where your thoughts and your actions are one and the same, maybe. But of course, it's important to say this, the Talmudic rabbis and everybody who followed them recognized that lots of us have venal thoughts. And we learn to screen the thoughts that we have from the words that we say, from the actions that we do. And the great danger in a Neuralink world is the inability to distinguish between the venal thoughts that we all have and the proper actions that we all know we should do. And we bridge this gap by being better people in practice than we actually are in theory. All of us are somewhat venal in our heart. Maybe not, maybe just me. I'm content to say maybe just me. But what I've learned is that it's very hard to read my heart, and you, and even my wife of many years and my family only judge me at most by the words I say and the actions that I do. And I aspire to say good words and do good actions, even if my heart has occasional venal thoughts in them. And the great danger with telekinesis, a Neuralink, a bridging of the gap between my venal heart and my civilized tongue and my aspirations to have downright just hands, is that the gap will be conquered by my venal heart and not by my civilized tongue or my just hands. And I suspect that will happen, what will happen even in a Neuralink world, is we will retain enough control over the Neuralink to make sure that we put in place things that control the venal thoughts that we have, to make sure they don't turn into vile words or despicable actions. It would be a bad world in the Jewish tradition if all our evil thoughts promptly turned into evil actions. I'm sure I'm the only person in this world that's had evil thoughts, but let's just focus on me. I don't control my evil thoughts all the time. I let the thoughts run wild, and I control them at the tongue stage and at the hand stage. And if we construct a neural link that diminishes our ability to control that bridge, we will be a weaker society and not a better society. On the other hand, if we facilitate a society in which we do a better job turning our thoughts that we want turned into actions, that on the whole will make us a much better society. Many years ago, when I was a young man, I heard President Carter speaking. And President Carter said, "Many times I have lusted in my heart." And I remember being so impressed by his ability to say that in public, because what I understood President Carter to mean, and I say this in admiration for a man in hospice, is the lusting never went beyond the heart. And that made him a very, very, very good man. All of us have things in our head or our heart that we know are wrong. This area or that area, it doesn't really matter. And a neural link which diminishes the gap between our head or heart and our tongue will make us a weaker society. Never mind one that diminishes between our head and our heart and our hands. So my hope is that as telekinesis, neural links, and orthodoxy versus orthoprax gets narrowed, on the whole, that could be a very good thing, so long as we make sure that we do not let our evil thoughts turn readily into evil actions that we ourselves would never do. Privacy, to me, is to protect my hands from the evil thoughts that are in my head. Thank you very much.
Dr. Berman, if you'd like to take a few minutes to respond, maybe just a few, and then we'll open it up to questions.
Okay, here or yes.
Either one.
Yes. So thank you so much, Michael, for thoughtful responses. I would say really respond to the responses very, very briefly by agreeing to most of what you said. I'll add to the salad maybe Shoshana Zubov's concern about the right for future tense, which has its, I think, origin perhaps in the Jewish idea of tshuva, which has its, parallels in Christianity, Islam, and so on. The idea that we, venal thoughts we may have, or even evil conducts, we still have the right to be better in the future, right? That's fallibilism, pragmatic fallibilism. And this is just an overarching idea which has, I think, religious reverberations or origins, because it's not a technical question. It's not about electrodes. It's a very broad question of how do you appreciate the liability to mistake and the average person in law and the possibility of people in general to improve, to learn from past mistakes. And it is not a technical question. So, and it really influences the space that marginalized minorities and disempowered populations would suffer just by the mechanisms of how modern societies rule themselves, govern themselves, and surveil the citizens. So there is a broad question here, which has an important religious context, the view of the human person, and the possibility for repair and for responsibility. And this, I agree that it is a great concern about narrowing this space for choice. That there's a famous experiment by Benjamin Libet about the readiness of action, of whether we are really having the choice and the moral choice that we intuitively feel we have. Scientifically speaking, it is still contested, but there are serious questions there. But it seems that certain technological procedures would, as you said, just push away or push toward a certain limiting of the space for deliberating and being reflective about what's called in Jewish tradition Yetzer Hara, evil inclination. Is just broad term for our Tanatic rather than productive urges. So I thank you for your responses, and yes, look forward to another.
Right, so we'll go ahead and open it up for questions. Do we have any questions here in the audience? Yes, please speak loudly, and if you don't mind, Dr. Berman, when you answer, just summarize the question so that for the benefit of our audience, on Zoom.
And if you can say your name also.
I'm Jody Blank, professor of computer science and law at Mercer University's Business School, and I teach courses in law and ethics and privacy law, and I'm an Emory law grad and taught a course here as an adjunct years ago. A couple of things that were touched upon, as I'm sure you know, in the EU's GDPR, data protection or privacy is viewed as a fundamental human right. And a lot of what drove all of the rules to do that have come from that approach, which, if I understand you correctly, would be orthopraxy. The regime that they have is the most comprehensive and detailed privacy law in the world, and we get trickle-down effects that here in the US now from those banners you see all the time about cookies are all driven by the GDPR. Would that scheme that they now have be considered orthodoxy? And then how would those two relate to the approach that you're making?
Thanks, Professor Blank. If I understand you correctly, you're highlighting the GDPR as an important milestone. I agree, and suggesting or asking whether it could be considered as an orthopraxy, because
If I understand what you're saying is that the beliefs that basically drove the human dignity part of the GDPR come from the experience of the Holocaust and what Germany did with personal data, particularly religious, also sexual orientation, political views. And so that would be, if I understand you correctly, an orthopraxic approach.
yes, so I think it is generally speaking orthopractic in the goals as the GDPR aims to advance, right, and to limit the possibility of corporations to sell our private information, surely without our consent. So it seems to me that connecting the amount of cyanide to the Silicon Valley, the article by Jarsky and Mies that you mentioned, that the GDPR is Jewish, maybe a lowercase J, but it affiliates with moral sensitivities that are found in early Jewish Hebraic tradition that respects the right for privacy and for future tense in this regard. We call them again. I hope I encountered.
Thank you. Any other questions from folks who are here in person? Terry, or do we have a student?
Yield to our expert.
Oh, okay. David, you want?
All right, so, thank you so much for your presentation and for your responses. Honestly, it was, my name is Terry Montague. I'm here, Emory and fellow in the Center for the Study of Law and Religion. I'm conducting scholarship in the law and Christianity space. In Christian theology, there's a saying that all translation is interpretation. And it strikes me, while I agree with Professor Broyde's statement, and I agree with the distinction between orthopraxy and orthodoxy. While you all were speaking, what was coming to my mind is, oh Lord, you know my thoughts afar off. Search me, O God, and know my heart. Try me and know my thoughts. And if there be a wicked way in me, lead me in the way. So I see orthopraxy and orthodoxy in many ways on a continuum. And I see a real risk in intervening and reading thoughts before the thought has been allowed to work its way through the continuum into life. So that it becomes very important then to know who is doing the translation, the interpretation of those thoughts. And if at an early seminal stage of those thoughts, they get interpreted to mean something that they don't really mean, there's a whole distortion of reality, I think, and attribution of motives that can occur that gives me a great deal of pause. So I'm curious, since you inspired these thoughts, what's the implication for privacy law? And is there something in Jewish law that should give us cause for optimism that we have the knowledge, intelligence, impetus to protect ourselves in the right way as the technology develops?
Thank you, Terry. Yes, and here there's a perhaps historical zero-sum game, because there's a work that I learned about from the late Rabbi Jonathan Sachs, book by Aaron Oren-Zayan, Big Gods. And he's basically suggesting that the rise of big religions with big omniscient gods in the axial age, right, the birth of the big civilizations that we know, actually had, Oren-Zayan suggests, a benefit for the morality of the commons. Now, because most people are in need of like being inspected by some omniscient God, but now we face in a secularized or largely secularized age a possibility where the state or the governors are maybe harnessing this religious potential or capacity. So I'm not sure what you meant by all translations in interpretation, but what I hear from you is that there is a certain space, there's some time needed for the tree to grow and to bear fruits, relating to the important maxim that peers and pragmatists allude to: by their fruits you should know them, right? So within a strict technological orthodoxy, there is no distinction. It's just a singular point where our personality is quetched into into some form of really lacking the space for a space of reasons, because when we consider sharing, right, our thoughts, intentions, motivations with others, it takes time, right? This idea of gradual thinking in the space of reasons, this is all just evaporates when we are just decided from outside by some algorithm. So I'm not sure I met your question properly. I'll be happy to keep the conversation going later. Perhaps.
Wonderful. Do you want to ask your question?
I had the same question that Terry had, but in a different sense. It seems to me that all cross-examination, invasion of privacy, as you're trying to get information from the person being questioned, which that person is claiming to be private and trying to hide, whether they are or not is determined by that. And all that assumes that there is a basic gap between the all-knowing whatever and the person that you're dealing with. And that's just part of human experience anyway. And insofar as we know in the Bible, as you yourself pointed out, by God asking Adam, where are you? He's also respecting that space, so he's acting within that space. We don't know what God thinks, but we know that he consciously backs up and creates that space. All of us do that with our children. All of us do that with our students too. We leave them room in order to move, and we consciously do that. I don't think you're going to find an AI algorithm that's going to embody that. I don't think you're going to get Simpson into AI. It just seems to me a contradiction of how you do that. And if we did have some sort of link, mind, computer link where we could know anything that you want, you'd still be way out of your league. Because as soon as you got something, you have to ask that question of the link. Why did you not control your evil impulse? That's a question that in most cases, people actually don't know the answer to. It's not that they know the answer and they're hiding it. It's that they actually don't know what the answer to that question is. And you would need some sort of psychoanalytic theory or some other kind of psychological theory to try to answer that question, which itself would be questionable. I'm not sure that we're improving anything by establishing a meta link. You might be able to establish facts. You might be able to establish partial motives, but you could do that with lesser ability in an ordinary cross-examination, it seems to me. So I think there's an element of irreducibility in this process, both from the point of view of the questioner and from the ability of the questioned person being actually able to answer all questions.
I just wanted to point out, not that what you said is wrong, but frequently it's the goal of the legal system to reduce as much as possible in a particular case, the tension between what happened and why it happened. And in many matters, whether it's defamation law, where there's an intent to defame, or tort law, where there's an intent to harm, or criminal law, where there's an intent to do a crime, the primary interest of the legal system is exactly bridging the gap that you've labeled as unbridgeable, without denying that it's at some theoretical level unbridgeable. It's the central goal of any actual living system that wants to function in the real world, to bridge the gap between what happened and why. Because we punish people differently, depending on why they did something. So we have no choice but to work, albeit imperfectly, albeit without the complete merger that you use the Hebrew term symptom for combination, but yet nonetheless to bridge the gap in a way that allows us to say with a high degree of confidence, we are going to sentence this person to a harsher sentence because we are confident of the fact that they did this crime on purpose rather than by accident.
Or compulsion.
Or compulsion, yes.
You have a hard time.
Turn it over to Dr.
distinguishing
Berman.
compulsion.
Yes, sure. Thank you, David and Michael. Let me agree with David on that. Because we know that in physics, which is allegedly a simpler or less complex than the human mind, in physics there is this uncertainty principle, right? We can't really know everything about just inorganic items. So we lose one of the parameters. And a fortiori, it applies to the human mind, which is seemingly much more complex. And there is a wonderful saying by a professor, the late Professor John McDermott, scholar of William James, in his book, The Drama of Possibilities, saying the modern man is a victim of the inability to live with the irreducibility of shadows. Now, this sounds too poetic for a law school, perhaps even for a center for the study of learned religion. But I think that, of course, it doesn't undermine the quest for knowledge and for due process and to give the right answer to unknown questions. But we should recall this Webster 1630 insight that we live in a world that on the one hand wants to know everything, and this urge allegedly has prices for interpersonal trust, for humane processes. And that's where I agree with the concern about our ability to live as human beings. Now, I'm not sure because about the inability of technology to stimulate such reflective thinking. Think of ChatGPT, right? It's gradual, it is seemingly interactive in some sense. But I don't think it will allow the pedagogic, really, as you said, with Ayeka and with children, the educational process, which takes time when a person is encountered with reality, right? There's some sense of exteriority in Levinasian terms, and the need to be in a reality check, which is in tension with a pure orthodox technological world, and also with the purest inclination that you described, Hallie, right? There is this notion of judging intentions very, very strictly. Yet we should strive to do justice and yes, and not give up the quest for knowledge and pursuing truth and so on.
We have one question over here from Alexa, and then we also have a question online too, so.
Yeah, so we mentioned Elon Musk a little bit, and then we've been talking a lot about governments having this. And that, started me thinking about social media and how a lot of the algorithms on social media explicitly target those bad heart emotions, because that's what fuels clicks. These kind of like negative, evil heart things, that's the reactivity. That's what, they make the money off of that. So I'm wondering, like, seeing a difference between a government and their intention of like getting into that division between orthopraxy and orthodoxy, and how a private company would kind of get in there, and like the harms I feel like would be different, but still like drastically terrible. But I'm not sure how to kind of walk through that division, because we know the capitalist side, they like that bad negativity. They love the clickbait. They love the angry people, yelling and hooting and hollering. So just kind of walking through that.
Thanks, Alex.
Yeah.
Yes. So yes, there is this phrase, rage against the machine, and now, as you said, the machines or social media, or perhaps digital media, until it would be proven to be social, is encouraging rage and negative sentiments and so on, just for economic reasons. And then that's a great huge concern. And an Israeli philosopher of technology, also Micha Goodman, my friend, once suggested that there should be a regulation of this very, very specific algorithm that manages to really make the masses, be very, very anxious and to fight with one another and so on. And so that's a question about regulation. But here, perhaps, I think Goodman's proposal is orthopractic. And it's a question again about the various forms of phases of orthodoxy, because some of these phases are like rational, strict rationalism and dogmatism. Other phases are just illusionary or sentimental in some imbalanced sense. So there's a question here about social media, which merits a full discussion. but perhaps it can contribute as idea of orthopraxy in the context of how the public psyche is nourished, right? The diet of the people. And there are questions, of course, about the freedom also of the corporations to run these things. That's a good legal question.
Great. We do have one question online. We have about 2 minutes left, and the question is rather long. It's from Dr. Shlomo Pill, who is joining us by Zoom. So thank you for your question, Dr. Pill. So you may not be able to give the full response that you would want because of the time, but more of a question and more of an observation. It seems to me that the distinction between orthodoxy and orthopraxy within Judaism is not just a matter of what is knowable, external conduct, and what is unknowable, internal thoughts. It's also a matter of the concreteness of action and the amorphous and ever-evolving nature of thought and motive. Actions are determinate, thoughts and ideas are not. I think there is much in this within Judaism with respect to differing approaches to authority in halakha, law, and agadah, spiritual thought. And I think we find much about the value of keeping rules out of thoughts and motives precisely so that the ambivalence and multivalence of those thoughts can be allowed to develop in good directions. Curious your thoughts about this. Thank you.
Okay, yes.
We got 1 minute left.
Wonderful comment, question. First of all, I'm not sure that actions are as concrete and determined as we may think. In Judaism, there is this idea of גדולה תשובה שמהפכת זדונות לזכויות. The repentance is great, for it is in retrospect shifting sins into merit and vices into virtues. And you may think about it in additional, just non-Jewish contexts. On the other hand, yes, the thoughts are, I mean, dogmas are the attempt to stabilize the otherwise fluid realm of thought. So I would think that both are fluid, but also determined in some ways. I think I should speak, yes, with Shlomo.
Sounds great.
That coffee. That's a
sounds-
good point. Very good point.
And I think that's a wonderful, we meant it to be a beginning of a conversation or a continuation of a conversation. So we'll look forward to perhaps your future engagement on these questions. Thank you, Dr. Berman, for being here, and thank you for our panelists, and thank you all for being such an engaged audience and all of your wonderful questions. We hope to see you at an upcoming event with the center, and hope you have a good rest of your day. Thank you so much.